Can you change the beneficiary of an irrevocable trust? Have you ever wondered if you can change the beneficiary of an irrevocable trust? This question comes up often in estate planning discussions. Understanding the rules around irrevocable trusts is essential for anyone involved in estate planning. Generally, once an irrevocable trust is set up, you cannot change the beneficiary. This is because the terms of the trust are fixed to protect the beneficiary's interests and meet specific estate planning goals. When the grantor, the person who created the trust, passes away, the beneficiaries named in the trust document have vested rights. This means their interests are legally protected and cannot be altered at will. However, there are some limited situations where changes might be possible. First, if all beneficiaries and the grantor are in agreement, some jurisdictions allow modifications to the trust terms. This requires a legal process or amendment. But it can get complicated if there are minor or unborn beneficiaries who cannot consent. If the grantor is deceased or incapacitated, court approval may be necessary. Second, courts can approve changes to an irrevocable trust if there are changed circumstances that make the original terms impractical or inconsistent with the grantor's intent. This process usually involves filing a petition and obtaining judicial approval, which can take time and may incur costs. Another option is trust decanting. In some states, a trustee can transfer assets from the original trust into a new trust with different terms. This can include changing beneficiaries, but only if the trustee has the authority to do so under the trust and state law. It is important to note that the trustee cannot be a beneficiary when exercising this power. Some irrevocable trusts also have a provision for a trust protector. This is an independent third party who oversees the trust and may have limited authority to amend certain terms, including beneficiary designations, depending on the trust document. Lastly, in discretionary trusts, the trustee has the authority over distributions. While the trustee cannot change the beneficiary designation, they can decide how much and when to distribute to beneficiaries. This discretion affects the timing and amount of benefits but does not add or remove beneficiaries. In the realm of elder law and estate planning, it is vital to understand that irrevocable trusts are designed to be stable. Any attempt to change beneficiaries must be carefully evaluated for legal authority and the trust's terms. Consulting with legal counsel is essential when considering modifications to irrevocable trusts. Improper actions can lead to litigation or unintended tax consequences. So while changing the beneficiary of an irrevocable trust is generally not allowed, there are exceptions that depend on consent, court intervention, decanting, or trust protector powers.